Dear Mr. President, Chief Justice Roberts, and Associate Justices, Attorney General Bondi, Speaker Johnson, and Majority Leader Thune. In recent years, I, like many others, have become increasingly frustrated by the disconnect between the people and those who are supposed to represent us. The issues outlined in this letter are not merely policy concerns or differences of opinion. They are fundamental breaches of trust, accountability, and the principles that our country was founded on. As a concerned citizen, it is no longer enough to stand idly by. These matters affect the very core of our constitutional republic, and it is time for the voices of everyday Americans to be heard. What follows is not just a complaint, but a call for action in the face of systemic failures that demand immediate attention and resolution. 1. Failure to acknowledge prior petitions. Since January 20th to April 18th, 2025, I have dispatched more than a half dozen first-class letters to the White House, the Supreme Court, and leadership in Congress. Not one confirmation of their receipt, not even the courtesy of a staff-generated form email. The right to petition the government for a redress of grievances, U.S. Constitution First Amendment, is mocked when those petitions vanish into a bureaucratic oubliette. 2. Article 3. Boundaries and the Runaway District Bench. A. Nationwide temporary restraining orders. Issued by single district judges. Judge James Boasberg has recently been involved in cases challenging the Trump administration's use of the Alien Enemies Act to deport Venezuelan nationals. In JGG v. Trump and WMM v. Trump, Boasberg issued temporary restraining orders, TROs, that effectively halted certain deportations, though he did not issue a broad nationwide preliminary injunction against the administration's policies. His rulings focused specifically on protecting the due process rights of the individuals involved, requiring that they be given a chance to contest their deportations. While the TROs had a nationwide effect for the classes of plaintiffs covered, they were not sweeping injunctions against Trump's immigration policy as a whole. Judge John Tegar, a federal judge in the Northern District of California, presided over East Bay Sanctuary Covenant v. Biden, found in Volume 384 of the Federal Supplement, 3rd Series, starting at page 844, decided in 2019, where he blocked a Trump administration rule that barred asylum applications from migrants who crossed the southern border outside official ports of entry. Tegar issued a nationwide preliminary injunction, finding that the new rule conflicted with the clear text of the Immigration and Nationality Act, which allows anyone physically present in the U.S. to apply for asylum, regardless of where they entered. His ruling emphasized statutory compliance and procedural fairness, not broader immigration policy. The injunction applied nationwide, affecting all asylum claims under the challenged rule. Judge Derek Watson, a federal judge in the District of Hawaii, presided over Hawaii v. Trump, found in Volume 245 of the Federal Supplement 3rd Series, starting at page 1227, decided in 2017, which challenged the Trump administration's second executive order temporarily restricting entry from several majority Muslim countries. Watson issued a nationwide temporary restraining order, TRO, blocking the enforcement of key parts of the travel ban, finding that the plaintiffs were likely to succeed on their claim that the order violated the Establishment Clause by discriminating based on religion. His ruling focused on constitutional concerns and the government's stated justification for the policy, and the nationwide scope of the TRO prevented enforcement of the executive order across the entire United States. The judicial power shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Article 3, Section 1. Inferior courts are therefore inferior. Their writ cannot outrun their geographic jurisdiction. See United States v. Mendoza, found in Volume 464 of the United States Reports, starting at page 154, with specific reference to pages 160 to 161, decided in 1984, cautioning against one district judge's veto over the government's program. B. Encroachment on Article 2. The court in Trump versus Hawaii, found in Volume 138 of the Supreme Court Reports, starting at page 2392, decided in 2018, reaffirmed that subsection 1182F is a comprehensive delegation to the president. When a lone judge bars that power coast to coast, separation of powers is inverted. Federalist number 78 warns against judicial usurpation. Federalist number 48 reminds us liberty is lost when the branches blend. How is it possible for a judge like Boasberg to hold President Trump in contempt of an order that was vacated by the Supreme Court? This seems like a fundamental question of judicial authority that should be covered in the very first year of law school. When the highest court in the land has vacated a ruling, how can any lower court or judge continue to enforce it as though it still holds weight? The fact that this issue has been allowed to persist raises serious concerns about the integrity of the judicial system and whether lower courts are still operating within the bounds set by the Supreme Court. 3. A neutral panel reform for extraordinary injunctions. 1. Threshold filter. Any temporary restraining order or preliminary injunction whose scope would extend beyond the issuing district and outside the home circuit must be docketed before a random 3-judge panel drawn daily from that circuit, a la military duty roster. 2. Fast-track review. If relief is granted, an automatic petition for certiorari is deemed filed. The Supreme Court must set an accelerated briefing schedule, 14 days merits, 7 days reply, and decide summarily or after argument within 45 days. 3. Opaque to forum shoppers. Because counsel cannot predict the daily roster, strategic venue gaming evaporates. Congress may codify this under its Article 3, Section 1 power. The court could adopt matching rules under 28 U.S.C., subsection 2072. 4. Chief Judge Boasberg and the appearance of impropriety. Chief Judge Boasberg's vacation-era intervention in an unsealed case, after Senator Schumer bragged of planting 230 judges to wage lawfare against a victorious Republican executive, reeks of orchestration. Offutt versus the United States, found in Volume 348 of the United States Reports, starting at page 11, decided in 1954, teaches that justice must not only be done, but appear to be done. 5. Electoral mandate as modern, alter, or abolish. When a Republican ticket wins 312 electoral votes, the national popular vote, and every swing state, Arizona, Georgia, Michigan, Nevada, Pennsylvania, Wisconsin, it satisfies the Declaration's instruction to alter a government destructive of ends of liberty. By peaceful ballot, our most accurate gauge of consent of the governed. 6. Executive Power 101, a pithy refresher. In Federalist 69 it says, President is Commander of the Army and Navy, the first General and Admiral, yet constrained by term and impeachment. In Federalist 70 it says, Energy on the executive is essential to the protection of the community. In Federalist 48 it says, each branch must have constitutional means to resist encroachment. Thomas Jefferson, in his letter to William Jarvis in 1820, warns us that the Constitution has erected no single tribunal with final word, and that if it had, it would make it a despotic oligarchy. 7. Foreign Policy Usurpation in the Logan Act, 18 U.S.C. subsection 953. Senators Freelance Diplomacy in El Salvador, March 2025, pledging asylum workarounds, is classic Logan Act interference. United States versus Curtis Wright Export Corporation, found in Volume 299 of the United States Reports, starting at page 304, decided in 1936, locates external relations solely in the President. 8. Selective outrage, January 6th versus non-citizens. The defendants of January 6th endured months of pretrial detention, subjected to a restrictive form of due process, to quote Judge Mehta's error-laden order. Many faced public humiliation while enduring aggressive prosecution and persecution. Their most basic rights, guaranteed by the Bill of Rights, were flagrantly denied under draconian provisions of the Patriot Act. Numerous judges in Washington, D.C. had no qualms about labeling them as domestic terrorists, simply due to the class of defendants they represented. In stark contrast, members of MS-13, Tren de Aragua entrants, and repeat border violators have been afforded multiple bites at the habeas apple, pro bono counsel, and NGO escorts. The same district court judges who treated American citizens with contempt are now attempting to grant quasi-citizenship to alien enemies, declared as such by the Alien Enemies Act and Article 2 proclamation, who have already undergone due process in Article 2 immigration courts. These judges are overstepping their authority by forcing deportation matters into Article 3 courts, thereby violating the Constitution's separation of powers clause. Equal justice blinded? No, she peeks from under the bandage to check the party label. 9. Deportation reality. Check. Let us look into the deportation history of the first term of the last 3 presidents and compare and contrast the data. President G.W. Bush, from 2001 to 2004, deported about 6.2 million illegal aliens with de minimis immigration lawsuits. President B.H. Obama, from 2009 to 2012, deported about 3.1 million illegal aliens with very few immigration suits, and the ones that were filed were dismissed quickly. President D.J. Trump, from 2017 to 2020, deported about 1.2 million illegal aliens with 55 national injunctions issued in immigration lawsuits. Now let's compare that to President Trump's current term. He has deported about 37,660 criminal illegal aliens, where multiple federal judges have blocked aspects of his immigration policies, including the use of the Alien Enemies Act and attempts to withhold funds from sanctuary cities. If the data prove anything, it is that litigation exploded only when removal policy aligned with the 2024 electorate's verdict. Can any fair-minded observer escape the conclusion that both courts and politicians have become self-interested gatekeepers rather than constitutional referees? 10. Congressionally complicit torpor. Republican majorities elected on November 5, 2024, promised border security, judicial reform, and accountability. Yet no single subject appropriations bill reaches the resolute desk, no impeachment inquiry into executive dereliction advances, and Paragraph 702 FISA reauthorization sailed through on autopilot. Federalist number 58 forewarned that the House of Representatives cannot more than partially be said to represent the people when it shirks their expressed will. 11. Department of Justice, charge or get out of the way. DOJ's own disclosures, Durham, Weiss, Hur, show probable cause against high-ranking officials. Equal protection is not vindicated by protecting the powerful. File the indictments, let discovery expose the rot, and if juries nullify, so be it. Sunlight is still the best disinfectant. 12. Vague mandates and Judge Sinis's misreading of facilitate. Judge Paula Zinnis, District Court, Maryland, trumpets the Supreme Court's April 10, 2025 order in Abrego Garcia v. Noem, number 825 CV 0951, as proof she can now compel the administration not merely to assist lawful reentry, but to surrender privileged diplomatic communications and internal deliberations for judicial inspection. The court's terse directive, however, said only to facilitate any lawful process for reentry, a verb that preserves, not extinguishes, Article 2 discretion over foreign affairs. Because Chief Justice Roberts declined to spell that out or rebuke the lower court, Judge Sinis is exploiting the ambiguity to pry into executive privilege and foreign relations prerogatives that the Constitution places beyond her reach. A Supreme Court order should never resemble a Rorschach test. Vagueness invites adventurism and erodes the predictability on which equal justice depends. Papatristo versus the City of Jacksonville, found in Volume 405 of the United States Reports, starting at page 156, decided in 1972, struck down a statute for vagueness. Judicial commands warrant no less precision. Chief Justice Roberts, the Constitution entrusts you to police the boundaries you draw. When inferior judges distort them, a perfunctory vacate and remand is inadequate. The court must speak unmistakably, or it abdicates its supervisory duty over the judiciary it leads. 13. Judicial overreach and constitutional illiteracy, a rebuttal to Justice Sotomayor's misguided dissent. Justice Sotomayor's assertion that Abrego Garcia was denied due process is not only legally erroneous, but constitutionally incoherent. Immigration is an Article II power, rooted firmly in the President's authority over foreign affairs and national sovereignty, not a matter for Article III courts to micromanage. Garcia received due process in 2 Article II immigration proceedings, a full hearing before an immigration judge, and a subsequent appeal, far more than the January 6th defendants, many of whom were denied bail, legal access, and speedy trials under the guise of domestic counterterrorism. To claim a lack of due process here is offensive on its face. Worse, Sotomayor's invocation of a 2019 order supposedly barring deportation to El Salvador is a demonstrable falsehood. That order clearly references Guatemala. A 5th grader could read the plain language of the ruling and comprehend this. Her misstatement is either gross negligence or willful deception. Moreover, Article 2 vests the executive, not the judiciary, with power over immigration and foreign relations, Federalist No. 70, U.S. Constitution Article 2, Section 2, and the intrusion of Article 3 judges like Boasberg, Shinnis, and the misguided minority on this court into such matters is not jurisprudence. It is usurpation. This is not compassion. It is a constitutional crisis enabled by ignorance and Chief Justice Roberts' abdication of principled leadership. Conclusion: a veteran's ultimatum. I am, without a doubt, the very definition of the common man. There are those to one side of me who are either too apathetic or too self-absorbed to even see what's happening around them. On the other side, there are those so far removed from the everyday struggles, either economically or politically connected, that they couldn't care less about anything other than their own interests. But it's in the center of that bell curve, across social, political, and economic divides, where you'll find the overwhelming majority of us. I'm the mean. I'm the average. I graduated 71st out of 72 in a small high school. I was an 11 Bravo, a grunt in the Army, a foot soldier. I've worked blue-collar, semi-white-collar jobs my whole life. Nothing about me is extraordinary, nothing except my commitment to this country and the Constitution. I've seen firsthand the abuse of the so-called justice system. I've watched county officials sue me for 2 years to take control of the local Republican Party. I've seen them tamper with votes, evidence of which I have, and interfere with elections. I've seen people arrested for simply speaking their minds, only to have charges dropped when the chairman of the county commission failed to show up in court and faced no consequences. I filed a federal lawsuit alone because I couldn't find a lawyer who would take it on, and I couldn't afford one. I had to drop it when the court did everything it could to block me, giving the defendants' lawyers special privileges while I was left with nothing. I know the corruption is real, from the local level to the state and all the way to the federal government. And I'm done standing by. It's time to act. I write not as a partisan, but as one who, like millions, swore to support and defend the Constitution. If the guardians of that charter continue to erase its lines, they will compel the people to exercise the residual right proclaimed on July 4, 1776, to throw off a government unmoored from consent. History teaches us the enduring truth of fiat justitia, ruat caelum, let justice be done, though the heavens fall. Consider this letter my final weather report. It is not a threat, but a historical warning and a reflection of deep frustration. I can no longer justify writing to my government representatives when the silence is one-sided. True communication must be mutual. Without it, the consent of the governed dissolves. Respectfully, but unflinchingly, John Paul Rutan, a grumpy old vet, Hillsdale, Michigan.